MRL3701, Hockly's Insolvency Law, Chapter 23, Winding Up of Companies. Introduction. The definition of debtor in Section 2 of the Insolvency Act expressly excludes a company which may be placed in liquidation under the law relating to companies, and hence the estate of such a company cannot be sequestrated. Instead, the company is wound up. Winding up means, essentially, the procedure by which a company's assets are sold, its debts are paid, and any money left over is divided amongst the shareholders according to their rights, or in the case of a non-profit company, transferred to other non-profit institutions. Both insolvent and solvent companies may be wound up in certain circumstances. After the process of winding up is complete, the Companies and Intellectual Property Commission, the Commission, records that the company has been dissolved and publishes a notice to this effect. At this point, the company ceases to exist. The winding up of companies is regulated by the following legislative provisions. Number 1. Sections 79 to 81 of the Companies Act No. 71 of 2008. These provisions deal with the winding up of solvent companies. Secondly, Chapter 14 or subsections 337 to 426 of the Companies Act No. 61 of 1973. This chapter, with certain exceptions, continues to apply to the winding up and liquidation of companies, as if the 1973 Act had not been repealed, in accordance with Section 224, subsection 3, read with Item 9, subsection 1, Schedule 5 of the 2008 Act. The chapter is to remain in effect until alternative legislation adequately providing for the winding up and liquidation of insolvent companies has been put in operation, as per Item 9, subsection 4A, Schedule 5 of the 2008 Act. However, certain provisions, such as Sections 343, 344, 346 and 348 to 353 do not apply to solvent companies except to the extent necessary to give full effect to Sections 79 to Sections 83 of the 2008 Act, as per Item 9, Subsection 2, Schedule 5 of the 2008 Act. And lastly, various provisions of the Insolvency Act. Section 339 of the 1973 Act states that, in the winding up of a company unable to pay its debts, the provisions of the law relating to insolvency must, insofar as they are applicable, be applied mutatis mutandis, in respect of any matter not specifically provided for by the 1973 Act. Other sections of the 1973 Act make particular areas of insolvency law applicable to the winding up of a company. See, for example, Section 340 for voidable dispositions, Section 342 for the application of assets to costs and claims, Section 366 for the proof of claims, Section 412 for meetings, Section 416 for interrogations, and Section 417 for inquiries. Some of these sections apply only to the winding up of a company that cannot pay its debts, such as Sections 340, 416, and 417. In this chapter, references to sections are to those of the 1973 Act, unless otherwise stated. Number 23.1. Modes of winding up and alternatives to winding up. A company may be wound up in either of two ways. Firstly, by the courts, or secondly, voluntarily, as per Sections 343, subsection 1, as well as Section 79, subsection 1 of the 2008 Act. Number 1. Winding up by the court, sometimes called compulsory winding up, is initiated by an application to court. The application is usually brought by a creditor in the case of an insolvent company and a shareholder in the case of a solvent company. Secondly, a voluntary winding up is initiated by a special resolution of the shareholders, as per Section 349 or Section 81, subsection 1 of the 2008 Act. The special resolution has to state whether the winding up is to be conducted by the creditors, that is, a creditor's voluntary winding up, or by the shareholders, that is, referred to as a member's voluntary winding up in the case of an insolvent company, as per sections 343, subsection 2, and a voluntary winding up by the company in the case of a solvent company, as per section 81, subsection 1 of the 2008 Act. The court may, on application by a creditor, a member, the master, or the company, convert a voluntary winding up into a winding up by the court. See here section 354, subsection 1, as well as section 79, subsection 3, and section 81, subsection 1A2 of the 2008 Act. Where a conversion takes place, the court may confirm any of the steps already taken in the voluntary winding up, as per section 354, subsection 1. As an alternative to being wound up, financially distressed companies may be placed in business rescue, provided there is a reasonable prospect that the company may be rescued. An application for business rescue must be preferred over a winding up application. The court can also make a business rescue order in any proceedings for the winding up of the company or for the enforcement of a security, as per section 131, subsection 7. A business rescue application suspends liquidation proceedings pending the adjudication of the business rescue application, and if a business rescue order is granted until the conclusion of the business rescue, as per section 131, subsection 6. It seems that the term liquidation proceedings in this context is not restricted to court proceedings leading up to a winding up order, but includes the entire process of voluntary or compulsory winding up even after a final winding up order. Despite the preference for business rescue, a court hearing a business rescue application may make a winding up order when it dismisses the business rescue application, as per section 131, subsection 4b. A company that is not in business rescue may resort to a compromise with its creditors. This mechanism can be used regardless of whether or not the company is being wound up. Number 23.2. Winding up by court. Number 23.2.1. Jurisdiction of court. Under section 12, subsection 1 of the 1973 Act, the court which had jurisdiction in regard to winding up was the High Court having jurisdiction over the area in which the company had its registered office or main place of business. It followed that if the company's registered office and main place of business were in different High Court areas, then both courts had jurisdiction. The 2008 Act does not expressly regulate jurisdiction over the person of a company, but it has been held that the court which has jurisdiction to grant a winding up order is the High Court having jurisdiction over the area in which the company has registered address. A company is obliged to have a registered address, and this has to be the location of its office in the Republic, or if it has more than one such office, its principal place of business, as per section 23, subsection 3b of the 2008 Act. Number 23.2.2. When company may be wound up by court. The grounds for winding up of a company are set out in section 344 for an insolvent company and section 81, subsection 1 of the 2008 Act for a solvent company. As will be observed, these grounds overlap to some extent. Some of the grounds mentioned in section 344 are not dealt with below because they are irrelevant or insignificant under the 2008 Act. Where application is made for the winding up of a solvent company on one of the grounds in section 81, subsection 1, and it appears that the company is or may be insolvent, the court, on application of any interested person, may order that the company be wound up as an insolvent company, as per section 79, subsection 3 of the 2008 Act. Number 1. Special resolution. The court may wind up a company, solvent or insolvent, if it has passed a special resolution to be wound up by the court, as per Section 344, subsection A, or Section 81, subsection 1A1 of the 2008 Act. Number 2. Failure to commence or continue with business. The court may wind up a company if it has not commenced its business within a year from its incorporation, or if it has suspended its business for a whole year, as per Section 344, subsection C. This ground should obviously apply to both solvent and insolvent companies, but not being mentioned in Section 81, subsection 1, it is limited to insolvent companies. Number 3. Loss of capital. The court may wind up a company if 75% of its issued share capital has been lost or become useless for its business, as per Section 344E. This is another example of a ground which was originally intended to apply to both solvent and insolvent companies, but which now applies only to the latter. Number 4. Inability to pay debts. The court may wind up a company if it is unable to pay its debts as described in Section 345 or Section 344F. However, this ground cannot be relied upon if the company is solvent despite being unable to pay its debts. In terms of Section 345, a company is deemed to be unable to pay its debts in the following cases. Number 1. A creditor to whom the company is indebted for at least 100 Rand, then due, has left a demand for payment at the company's registered office, and the company has neglected for 3 weeks thereafter to pay, secure, or compromise the claim to the satisfaction of the creditor, as per Section 345, subsection 1A. The requirement of delivery at the company's registered office is peremptory and must be strictly complied with. Pay in this context means pay unconditionally. Thus, the tender of a lesser sum in full and final settlement is not enough to avoid liquidation. Number 2. A warrant of execution or other process, issued on a judgment against the company, has been returned by the sheriff with an endorsement that he did not find disposable property sufficient to satisfy the judgment, or that the disposable property he found did not, upon sale, satisfy the process, as per Section 345, subsection 1b. Number 3. It is proved to the satisfaction of the court that the company is unable to pay its debts, as per Section 345, subsection 1c. In considering this question, the court may take into account the contingent and prospective liabilities of the company, as per Section 345, subsection 2, for the meaning of contingent and prospective. The source of payment is irrelevant, so a tender to pay by someone other than the company must be taken into account in determining its ability to pay. The fact that the company is factually insolvent may, depending on the circumstances, indicate that it is unable to pay its debts. Number 5. Dissolution of external company. The court may wind up an external company if it has been dissolved in the country in which it was incorporated, or has ceased to carry on business, or is carrying on business only for the purpose of winding up its affairs, as per Section 344, subsection G. This ground relates only to an insolvent external company. An external company registered as such in South Africa may be liquidated as if it were an independent entity, even if the foreign company to which it is related is not liquidated or dissolved. It follows that such a company may be subjected to 2 simultaneous and concurrent liquidation processes, one in South Africa and the other in its country of incorporation. Number 6. Just and equitable. The court may wind up a company, solvent or insolvent, if it appears that it is just and equitable that the company should be wound up, as per Section 344, subsection H, or Sections 81, subsection 1C2 and subsections D3 of the 2008 Act. The court do not regard the just and equitable ground as some limitless or catch-all ground for winding up a company. They generally resort to it in specific categories of cases only, and are reluctant to extend its application. The courts have held that it is just and equitable to wind up a company in the following instances. Number 1. Where the main object for which the company was formed is not possible of being attained. In other words, the company's substratum has failed or disappeared. This in Ray Renosterkopper Co. 1908, the court wound up a company in which had been formed to acquire and exploit certain mining rights because the land subject to the rights was devoid of minerals. Again, in APCO Africa Proprietary Limited and another versus APCO Worldwide Incorporated 2008, the court wound up a company which lacked infrastructure of its own and which was unable to obtain work because of a deadlock between its shareholders. The court found that the company depended for its existence on work being referred to it by one of its corporate shareholders, and that the deadlock between the shareholders had resulted in the disappearance of the company's substratum. Number 2. Where the company's objects are illegal, or the company was formed to defraud the persons invited to subscribe for its shares. In Cunningham and another versus First Ready Development 249, Association Incorporated under Section 21 of 2010, the court wound up a company incorporated as an association not for gain because its real purpose was to conduct a commercial business for gain. Number 3. Where there is a justifiable lack of confidence in the conduct and management of the company's affairs. For a lack of confidence to be justifiable, it must relate to the conduct of the directors in carrying on the company's affairs, not their private lives. Mere dissatisfaction at being outvoted on business matters or policy issues is not enough. An example of a justifiable loss of confidence is provided by the case of Musa N.O. versus Mavjibawan Proprietary Limited and another 1967. Please forgive my pronunciation. The sole director of a company had misled the members into believing that it would be uneconomical for a company to renovate and retain a valuable piece of property, and that the company should rather sell the property. The director had done this fraudulently, with the intention of securing the asset for himself. The court held that the members' loss of confidence in the director had been warranted, and that it was just and equitable that the company should be wound up. Number 4. Where the voting power in the board of directors or in the general meeting of the company is so divided between dissenting groups that the deadlock cannot be resolved except by winding up the company. A deadlock in management commonly arises where there are only 2 directors or 2 shareholders holding equal voting rights and they have developed irreconcilable differences. However, the phenomenon is not confined to small domestic companies. In view of the inclusion of 2 narrowly circumscribed deadlock situations as grounds for the winding up of solvent companies, as per Section 81, subsection 1d 1 to 2 of the 2008 Act, see X below, the just and equitable grounds in Section 81, subsection 1d3 does not cover other instances of absolute deadlock. The so-called deadlock principle, which refers to the breakdown of a relationship of confidence and trust, can still be invoked under Section 81, subsection 1d3. Number 5. Where the company is a quasi-partnership and the circumstances exist which would be good grounds for dissolving a partnership. Some companies are founded on a personal relationship of confidence and trust similar to that existing between partners in regard to the partnership business. This relationship usually requires the members to act reasonably and honestly towards each other and with friendly cooperation in running the company's affairs. If one or more of the members act contrary to the spirit of this relationship and in doing so effectively destroy it, the court may hold it just and equitable to wind up the company. In Ibrahimi versus Westbourne Galleries Limited, 1973, E and N, who had been partners in a business, who formed a company in which they were members and directors. N and his son, who together held the majority of shares, subsequently passed a resolution dismissing E as a director. The court held that the dismissal, although permitted by the articles of the company, violated the personal relationship between the parties. Hence, it was just and equitable that the company should be wound up. And lastly, where the minority shareholders are oppressed by the controlling shareholders. However, the court may refuse a winding up order in this type of case if the oppression can be removed with some other remedy, for example, by interdicting the wrongdoers from continuing their oppression, or by making an order compelling the company or certain of its members to buy the shares of the aggrieved minority. Where the company is insolvent, alternative measures are unlikely to be considered unless they also address the financial situation of the company. Number 7. Conversion of voluntary winding up into a winding up by court. The court may wind up a solvent company that has commenced a voluntary winding up if the company applies to have the winding up continued by the court, as per Section 81, subsection 1A2 of the 2008 Act. Number 8. No reasonable prospect of business rescue succeeding. The court may wind up a solvent company that is in business rescue if the practitioner concludes that there is no reasonable prospect of the company's being rescued, as per Section 81, subsection 1b. Given that only solvent companies may be wound up on this ground, it is unlikely to be of much use in practice. The 1973 Act does not contain a similar ground for insolvent companies, and a business rescue practitioner cannot bring an application on any of the grounds mentioned in Section 344. Number 9. Termination of business rescue proceedings. The court may wind up a solvent company that has commenced business rescue proceedings if the proceedings have ended in the manner contemplated in Section 132, subsection 2b, or subsection c1, the filing of a notice of termination or rejection of the proposed business plan, and it appears just and equitable in the circumstances for the company to be wound up, as per Section 81, subsection 1c1. Number 10. Deadlock in management or voting. The court may wind up a solvent company where either of the following situations exist. Number 1. The directors are deadlocked in the management of the company. The shareholders are unable to break the deadlock, and as a result of the deadlock, firstly, irreparable injury to the company is resulting or may result, or secondly, the company's business cannot be conducted to the advantage of the shareholders generally. Number 2. The shareholders are deadlocked in voting power and have failed for a period that includes at least 2 consecutive annual general meeting dates to elect successors to directors whose terms have expired, as per Section 81, subsection 1d 1 to 2. Number 11. Fraud, illegality, or misapplication of company assets. The court may wind up a solvent company on the grounds that, number 1, the director, prescribed officers, or other persons in control of the company are acting in a manner that is fraudulent or otherwise illegal, or number 2, the company's assets are being misapplied or wasted, as per Section 81, subsection 1e 1 to 2. Number 12. Failure to comply with compliance notice. The court may wind up a solvent company where, number 1, the company, its directors, prescribed officers, or other persons in control of it are acting or have acted in a manner that is fraudulent or otherwise illegal. The commission or panel has issued a compliance notice in respect of that conduct, and the company has failed to comply with the notice. And number 2, within the previous 5 years, enforcement procedures in terms of the 2008 Act or the Close Corporations Act No. 69 of 1984 were taken against the company, its directors or prescribed officers, or other persons in control of it for substantially the same conduct, resulting in an administrative fine or conviction for an offence, as per Section 81, subsection 1F1 to 2. Number 23.2.3. Parties who may apply for winding up of insolvent company. Section 346 says who may apply to court for the winding up of an insolvent company. The onus in each case is on the applicant to establish that he has the requisite locus standi to bring the application. Number 1. The company. The company itself may bring the application, as per section 346 subsection 1a. There is a difference of opinion on whether the company must be authorized by a special resolution of members passed in a general meeting, or whether the company may act on a resolution of directors. In ex parte Tangent Sheeting Proprietary Limited 1993 and ex parte Graafreinet Rollermeule EDMS BPK 2000, the courts held that the directors could validly resolve to apply, as the word company does not necessarily mean the company in general meeting, and the concept of managing the business of a company could include deciding that it should apply for its winding up. In ex parte Rislane Construction Proprietary Limited 1987, as well as ex parte Screen Media Limited 1991 and ex parte New Seasons Auto Holdings Proprietary Limited 2008. The courts took the view that the answer depended on what powers the company's articles of association conferred on the board of directors. In each of these cases, it was found that the articles in question did not give directors the power to terminate the company's business. The 2008 Act expressly provides that directors are to manage the company's business and affairs, and further states that the board may exercise all the powers and perform all the functions of the company, except where the Act or the company's memorandum provides otherwise, as per section 66, subsection 1 of the 2008 Act. This wide wording suggests that the board can determine whether the company should apply. It is submitted that the requiring only a board decision is the preferable approach. Convening a meeting of members may be an expensive exercise, a cost an impecunious company can ill afford, and in the case of a large company may take some time. The delay may not only harm the company and its creditors, but it may also work to the prejudice of the directors, who may, under a duty to end the activities of the company, promptly to avoid the charge that they carried on the business of the company recklessly. Number 2. One or more creditors. An application may be brought by one or more creditors, including contingent or prospective creditors, in terms of section 346 subsection 1b. The creditor's claim need not equal or exceed any particular amount, as it must in application for compulsory sequestration. The requirement in section 345 subsection 1a of a liquidated claim of 100 Rand is relevant only to proof of the company's inability to pay its debts. A contingent or prospective creditor is one with a claim against the company which will only become enforceable in the future. The expression includes, for example, a party who has lent money repayable on a date which has not yet arrived, a surety for the company, and a person with a damages claim, the amount of which has not yet been quantified by the court. It does not include the claim of a preference shareholder. Number 3. One or more of its members. An application may be brought by one or more of the company's members or by a person appointed as executor, trustee, liquidator, curator, or guardian in respect of a member who is deceased, insolvent, or under a disability, as per section 346, subsection 1c, as well as section 103, subsection 3. However, a member may not apply unless he has been registered as such in the register of members for at least 6 months prior to the date of the application, or unless the shares he holds have devolved upon him through the death of a former holder, as per section 346, subsection 2. Further, a member may not apply on the grounds mentioned in 23.2.2, 1, 6 or 7 above, that is, a special resolution, an inability to pay debts, or a dissolution of external company. as per section 346, subsection 2. It will be observed that the members of a company have various ways of initiating the winding up of a company. Number 1. The members may resolve by special resolution to proceed with the members' voluntary winding up of a company. Number 2. The members may resolve by special resolution to proceed with the creditor's voluntary winding up of the company. Number 3. The members may resolve by special resolution that the company should apply to court for a winding up order. The application may be founded on any of the grounds stated in section 344, including the fact that the company is unable to pay its debts. And lastly, one or more members who can meet certain requirements may apply to a court for a winding up order. The application may only be brought in some of the grounds stated in section 344. Most importantly, it cannot be founded on the inability of the company to pay its debts. An application for a winding up order on this ground can only be brought by the company itself, acting pursuant to a special or perhaps director's resolution. One or more creditors of the company, the master, or provisional or final judicial manager. Number 4. Any or all of the above parties. The application may be brought jointly by some or all of the parties mentioned above, that is, the company, creditors, and members, as per section 346, subsection 1d. Number 5. The master. As mentioned above, the master may apply to convert a voluntary winding up into a winding up by the court, as per section 346, subsection 1e. This is the only instance where the master may apply for the winding up of a company. The reason why the master would want to convert a voluntary winding up into a winding up by the court is usually to make available the procedure for examination and inquiry under sections 417 and 418. The most probable ground for the winding up on which the master will base his application is the inability of the company to pay its debts. And number 6, a provisional or final judicial manager. A provisional judicial manager may bring the application where the provisional order of judicial management is discharged, as per section 346, subsection 1f. This provision does not preclude a creditor from applying for the winding up of a company under judicial management. A final judicial manager is obliged to apply for the winding up if it appears to him that the company he is managing will not become a successful concern, as per section 433, subsection 1. Although the judicial management provisions have been repealed by the 2008 Act, this provision remains relevant to the judicial managers appointed under the 1973 Act. Number 23.2.4. Parties who may apply for winding up of solvent company. Section 81, subsection 1 of the 2008 Act deals with the question of who may apply for the winding up of a solvent company on the grounds specified in that section. The list below sets out the different grounds and the person or persons entitled to apply in each instance. As will be observed, the question of who has locus standi varies according to the basis of the application. Number 1. Special resolution may be applied for by the company. Number 2. Just and equitable. The company, one or more directors, one or more shareholders, or one or more creditors, as per section 81, subsection 1d and section 81, subsection 1c2. Number 3. Conversion of voluntary winding up into winding up by the court is the company, as per section 81, subsection 1a2. Number 4. No reasonable prospect of business rescue succeeding. That would be the practitioner of the company appointed during the business rescue proceedings, as per section 81, subsection 1b. Number 5. Termination of business rescue proceedings. That would be one or more creditors, as per section 81, subsection 1c. Number 6. Deadlock in management or voting. That would be the company, one or more directors, or one or more shareholders, as per section 81, subsection 1d. Number 7. fraud, illegality, or misapplication of company assets. That would be any shareholder with leave of the court, as per Section 81, subsection 1E. And lastly, failure to comply with compliance notice. The Companies and Intellectual Property Commission or Takeover Regulation Panel, as per Section 81, subsection 1F. A shareholder may not apply to wind up the company on the basis of a deadlock in management or voting, or on the ground of fraud, illegality, or misapplication of company assets unless he has been a shareholder, or he and the party from whom he acquired the shares have been shareholders continuously for at least 6 months prior immediately before the date of the application, as per Section 81, subsection 2. Number 23.2.5. Steps prior to application. Sections 346, subsection 3 to subsection 4a impose several requirements to be complied with in an application for a winding up order. It is uncertain whether these requirements apply in an application to wind up a solvent company, as Section 346 applies only to the extent necessary to give full effect to the provisions of Part G of Chapter 2 of the 2008 Act, as per Item 9, Subsection 2 of Schedule 5 of the 2008 Act. The better view would seem to be that the compliance with the requirements is necessary to give full effect to Sections 79 to Section 81 of the 2008 Act. See here Section 79, Subsection 2 of the 2008 Act. And accordingly, the requirements are also applicable to the winding up of solvent companies. Number 1. Security for costs. A party applying for winding up must give sufficient security for the repayment of all fees and charges necessary for the prosecution of all winding up proceedings, and all costs of administering the company in liquidation until a provisional liquidator has been appointed, or if none is appointed, of all fees and charges necessary for the discharge of the company from the winding up, as per Section 346, subsection 3. The application must be accompanied by a certificate issued by the master not more than 10 days before the date of the application, to the effect that this security has been given. Number 2. Master's Report. Before presenting his application to the court, the applicant must serve a copy on the master, who may report to the court any facts which he has ascertained which may justify postponing or dismissing the application, as per Section 346, subsection 4. Number 3. Notification of certain interested parties. When presenting the application to court, the applicant must also furnish a copy of it to the following, as per Section 346, subsection 4a, subsection a, 1 to 4. Number 1. Every registered trade union that, as far as the applicant can reasonably ascertain, represents any of the company's employees. Number 2. The employees themselves, by affixing a copy of the notice to any board accessible by the applicant and the employees inside the company premises, or if there is no such access, by affixing a copy either to the front gate of the premises or to the front door of the premises from which the company conducted any business at the time of the application. Number 3. The South African Revenue Service. And lastly, the company, unless the application is made by the company, or unless the court, in its discretion, dispenses with the furnishing of a copy where the court is satisfied that it would be in the interests of the company or of the creditors to dispense with it. Further, the applicant must, before or at the hearing, file an affidavit by the person who furnished a copy of the application, stating how the above requirements were met, as per Section 346, subsection 4a, b. Number 23.2.6. Powers of Court. The court may not grant a winding up order on the grounds listed in Section 81, subsection 1e. That would be fraud, illegality, or misapplication of company assets. Or Section 81, subsection 1f. That would be the failure to comply with a compliance notice. If, before the conclusion of the court proceedings, the director or directors implicated in that conduct have resigned or have been removed, and the remaining directors are not materially implicated, or if one or more of the shareholders have applied for an order of delinquency against the director or director responsible for the misconduct, and the court is satisfied that their removal would bring an end to the misconduct, as per Section 81, subsection 3 of the 2008 Act. The court may grant or dismiss any application for winding up, or adjourn the hearing thereof, conditionally or unconditionally, or make an interim order or any other order it may deem just, as per Section 347, subsection 1. In practice, the court usually does not make a final order immediately. It makes a provisional winding up order, provided the applicant has made out a prima facie case, and issues a rule nisi calling on all interested parties to show cause in the return dates of the rule why the court should not make an order placing the company under final liquidation. However, the Act does not oblige the court to make a provisional order, and it may, if it deems appropriate, make a final order immediately. For instance, where the issues have been fully ventilated and nothing has been suggested or put forward to indicate that further relevant facts would be forthcoming if a rule nisi were issued. The court's power to grant an application for winding up is discretionary, irrespective of the grounds on which it is sought. When a court is faced with the choice between business rescue and winding up, the former must be preferred. While it was previously accepted that creditors have a right to a winding up order where a company is unable to pay, this approach has been tempered by the availability of business rescue proceedings. However, winding up is more appropriate than business rescue when dispositions made by the company may need to be set aside, or where the company is involved in legal disputes, particularly pertaining to contracts such as leases of immovable property that could simply be terminated by a liquidator, where there is a deadlock between the shareholders, or where there is a lack of up-to-date financial information about the company. The court may not refuse a winding up order merely because the company has no assets or because its assets have been mortgaged to their full value, as per Section 347, subsection 1. And unlike in the case of an application for sequestration, the court need not be satisfied that winding up will be to the advantage of the company's creditors, although the likelihood or otherwise of a dividend is obviously an important factor for the court to consider. Where the company disputes allegations of facts in the creditor's application, the court may make a provisional winding up order only if it is satisfied from all the papers filed that the requirements for a winding up order have been satisfied on a balance of probabilities. On the return day, the court may refer one or more disputed questions of fact to oral evidence or postpone the application pending the outcome of a trial action. The court will ordinarily not grant a provisional winding up order if the company bona fide and on reasonable grounds disputes its indebtedness to the creditor, although the rule here is not entirely inflexible. In such a case, it does not matter that the creditor has made out a case on a balance of probabilities. The reason for refusing the order is essentially that the application amounts to an abuse of the winding up procedure. The courts have frequently emphasized that the procedure for winding up is not designed for the resolution of disputes as to the existence or non-existence of a debt, and that a party should not resort to the procedure as a means of putting pressure on a company to pay a debt which the company genuinely disputes on reasonable grounds. To resist the application successfully, the company does not have to establish that it would prove to or succeed with its defense. It merely has a bona fide to allege facts which, if proved, would constitute a good defense to the claim. Where the application is presented by the members of the company, the court will not make a winding up order if some other remedy, for example, relief in terms of Section 163 of the 2008 Act, is available to the applicants and they are acting unreasonably in seeking to have the company wound up instead of pursuing that other remedy. as per section 347 subsection 2. In Tron versus Phoenix Marketing Proprietary Limited, 1998, the court refused to make a winding up order on the just and equitable ground because the applicant shareholder had failed to adhere to the terms of a shareholder agreement which obliged him to offer his shares to the other shareholders before resorting to an application for winding up. Number 23.3. Voluntary winding up. An insolvent company may be wound up voluntarily if it has adopted a special resolution to that effect, as per section 349, and that resolution has been registered by the Commission in accordance with the formalities laid down in section 200, or section 350, subsection 1 and 351, subsection 1. A special resolution to wound up a company must state whether the winding up is a member's voluntary winding up or a creditor's voluntary winding up. A solvent company may be wound up voluntarily if it has adopted a special resolution to this effect and filed it with the Commission, as per section 80, subsection 1 to 2 of the 2008 Act. The resolution must provide for the winding up to be by the company or by its creditors, as per section 80, subsection 1 of the 2008 Act. Number 23.3.1. Members' voluntary winding up and voluntary winding up by the company. A member's voluntary winding up and a voluntary winding up by the company can take place only if the company is able to pay its debts in full. Before the process can proceed, number 1. Security must be furnished to the satisfaction of the master for payment of the debts of the company within 12 months from the beginning of the winding up. Or number 2. The master must dispense with such security. The master may do this only upon receiving an affidavit by the directors of the company that it has no debts, and a certificate by the auditor of the company, or if the company does not have an auditor, a person meeting the requirements for appointment as auditor, that to the best of his knowledge and belief, and according to the records of the company, it has no debts, as per section 350, subsection 1, as well as section 80, subsection 3 of the 2008 Act. A member's voluntary winding up or voluntary winding up by the company may be resorted to for a variety of reasons. For example, the purpose for which the company was formed may have been fulfilled, or the members responsible for running the company may no longer be on amicable terms. The procedure is simpler and quicker than a winding up by the court, or a creditor's voluntary winding up. The members control the process throughout. Creditors do not prove their claims or hold meetings. Although the notion of an insolvent company under members' voluntary winding up may seem strange, it is not impossible for a faculty or commercially insolvent company to arrange security for the full payment of its debts. The provision for a voluntary winding up by a special resolution of shareholders cannot be excluded from the company's articles of association, and a court will not interfere with an exercise by the requisite majority of shareholders of the right to resolve that the company may be voluntarily wound up. Number 23.3.2. Creditors' voluntary winding up. A creditor's voluntary winding up, unlike a member's voluntary winding up or voluntary winding up by the company, may be resorted to where the company is unable to pay its debts. A creditor's voluntary winding up can be of a solvent or insolvent company, as per section 79, subsection 1A2 of the 2008 Act, and section 343, subsection 2A, as well as section 351. A solvent company might wish to resort to this type of winding up where it has debts but is unable or unwilling to furnish security for the full payment of its debts within 12 months. The procedure resembles a winding up by the court in that meetings of creditors are held and the liquidator is subject to the directions of the creditors who have proved claims. The procedure may aptly be described as a voluntary winding up under creditors' supervision. The directors must prepare a statement in the prescribed form of the company's affairs and lay it before the meeting convened to pass the resolution, as per section 363, subsection 1. Certain criminal provisions which apply to a winding up by the court do not apply to a creditor's voluntary winding up, as per section 425. Number 23.4. Consequences of winding up. Number 23.4.1. Commencement of winding up. A winding up by the court of an insolvent company is deemed to commence at the time of the presentation to court of the application for the winding up, as per section 348. An application for winding up is presented to the court for these purposes when the papers are duly lodged with the registrar of the court. The phrase "at the time" is given its ordinary meaning, namely, at that specific point in time, rather on the day or date in question. If two or more applications are made, the winding up commences as soon as any of them is lodged with the registrar, irrespective of whether security in respect of this application was lodged first, and even if the final winding up order is granted on another application. In this case of Null and Others, NNO versus the Master and Others, a provisional winding up order brought by one creditor was discharged and immediately replaced by a final order granted at the instance of an intervening creditor. It was held that the winding up commenced on the date when the original application was lodged with the registrar. A winding up by the court of a solvent company begins when the application has been made to the court on one of the following grounds. Number 1. The company has adopted a special resolution that it be wound up by the court. Number 2. The company has applied to court to have its voluntary winding up continued by the court. Or lastly, the business rescue practitioner has applied for liquidation on the ground that there is no reasonable prospect of the company being rescued, as per section 81, subsection 4a, read with section 81, subsection 1a to b. In all other cases, the winding up by the court of a solvent company begins when the court has actually made the winding up order, as per section 81, subsection 4b. The voluntary winding up of an insolvent company commences when the relevant special resolution of members is registered with the Commission in terms of section 200. The voluntary winding up of a solvent company begins when the special resolution is filed with the Commission, as per section 80, subsection 6. Determining the precise time of commencement is important because various consequences of winding up come into effect when the winding up commences, as opposed to when the court makes a provisional or final winding up order. Number 23.4.2. Directors divested of powers and control. Winding up, like sequestration, establishes a concursus creditorum, which is aimed at ensuring that the company's property is collected and distributed among creditors in the prescribed order of preference. The concursus creditorum is established by the granting of a winding up order, including a provisional order. The company does not lose its corporate identity, as per section 353, subsection 1, as well as section 80, subsection 8A of the 2008 Act in relation to voluntary winding up of a solvent company, nor does it lose title to its assets, unless so ordered, as per section 361, subsection 2. But from the moment the winding up commences, the following consequences ensue. Number 1. The powers of directors cease and the directors become functus officio. In a voluntary winding up, the liquidator, creditors, or members may sanction a continuance of directors' powers in whole or in part, as per section 353, subsection 2, as well as section 80, subsection 8b2 of the 2008 Act in relation to voluntary winding up of a solvent company. Number 2. The company's property is deemed to be in the custody and under the control of the master until a provisional liquidator has been appointed and has assumed office, as per section 361, subsection 1 to 2. A company thus retains the dominion of its property. Section 339 does not have the effect of applying Section 20, subsection 1c of the Insolvency Act, which divests an insolvent of his assets to the winding up of a company that is unable to pay its debts. Number 3. The company may not continue with its business, except insofar as it may be necessary for its beneficial winding up. See Section 353, subsection 1, as well as Section 80, subsection 8b(1) of the 2008 Act in relation to voluntary winding up of an insolvent company. Number 23.4.3. Subsequent unauthorized dispositions void. After the winding up of a company has commenced, number 1. Any transfer of shares of the company without the liquidator's permission is void, as per section 341, subsection 1. And number 2, if the company is unable to pay its debts, every disposition of its property, including rights of action, not sanctioned by the court is void, as per section 341, subsection 2. Furthermore, no set-off can take place unless mutuality of the respective claims existed at the time of the winding up. In deciding whether to sanction a disposition made after the commencement of winding up, the court has regard to all the circumstances and, in particular, the good faith of or otherwise of the recipient and the company and the interests of the general body of creditors. The court's discretion applies only to dispositions after the deemed commencement of winding up, but before a winding up order has been made. Number 23.4.4. The stay of proceedings. Once a winding up order is made or a special resolution for voluntary winding up is registered or filed, all civil proceedings, including judgments by or against the company, are suspended until the appointment of a liquidator, as per section 359, subsection 1a. An application for the winding up of a company is not a civil proceeding for these purposes, and may thus be proceeded with despite the registration of a resolution for the voluntary winding up. Any attachment or execution put in force against the assets of the company is void, as per section 359, subsection 1b. An attachment is put in force with the meaning of these words if, in pursuance of a writ of execution, the sheriff of the court takes possession of the property. If a sale in execution took place before commencement of the winding up but has not been completed, the sheriff may not give transfer to the buyer. After appointment of the liquidator, civil proceedings against the company may continue or commence provided the litigant concerned within 4 weeks of the liquidator's appointment gives him at least 3 weeks' notice in writing before continuing or commencing the proceedings, as per section 359, subsection 2. Civil proceedings here includes execution proceedings put in force before the commencement of the winding up order. So if the company's property has already been attached when the company is wound up, the creditor may continue with the execution after notice to the liquidator. However, he has no preferent claim in respect of the proceeds, other than for the costs of execution. The requirement of notice was enacted for the benefit of the liquidator alone, and accordingly it is unnecessary for a litigant to give notice to the liquidator where the defendant is a surety for the company and not the company itself. If notice of continuance of the proceedings is not given, the proceedings are considered to have been abandoned unless the court directs otherwise, as per section 359, subsection 2b. The court has an unfettered discretion to allow the continuation of proceedings and must have regard to the interests of the creditors, liquidators, and members. Number 23.4.5. Notice of winding up. The master must, on receipt of a winding up order, give notice of the winding up in the Gazette, as per section 356, subsection 1 and subsection 2b. The registrar of the court must transmit a copy of the winding up order to certain sheriffs and registrars of deeds, as per section 357, subsection 1 and subsection 3. A copy of the winding up order must also be served on: number 1. Any registered trade union that represents the company's employees. Number 2. The company's employees themselves, by affixing a copy of the application to a notice board accessible to them inside the debtor's premises, or to the front gate or to the front door of the premises from which the debtor conducted business when the application was presented. Number 3. The South African Revenue Service. And lastly, the company, unless it made the application, as per section 346A, subsection 1. To serve the winding up order, the sheriff must establish whether a registered trade union represents the company's employees, and whether the employees have access to such a notice board inside the company premises, as per section 346A, subsection 2. Where employees can no longer be found at the premises, personal notification will constitute substantial compliance with the notification requirement. An insolvent company which has passed a resolution for its voluntary winding up, that is, by creditors or members, must within 28 days after registration of the resolution give notice of the voluntary winding up in the Gazette and lodge a certified copy of the resolution with the master together with the following. Number 1. In the case of a member's voluntary winding up, a certified copy of any resolution passed by the company nominating a liquidator, as per section 356, subsection 2a(1). Number 2. In the case of a creditor's voluntary winding up, 2 certified copies of a statement in the prescribed form setting out the affairs of the company, as per section 356, subsection 2a(2). In the voluntary winding up of an insolvent company, the Commission has to deliver a copy of the filed resolution to the master, as per section 80, subsection 7 of the 2008 Act. Number 23.4.6. Lodging of Statement of Affairs with Master. Where the court has made a winding up order, the directors and officers of the company must prepare a statement in the prescribed form of the affairs of the company and lodge 2 certified copies with the master within 14 days of the date of the winding up order, or such further period as the master or the court may allow, as per section 363, subsection 2. The master may call upon any person who at any time during the year before the winding up order had been a director or officer of the company or had participated in the formation of the company to prepare the statement. The master must send a copy of the statement to the liquidator on his appointment. Number 23.5. Meetings and proof of claims. Number 23.5.1. Creditors' meetings. Creditors' meetings are held in a winding up by the court and in a creditor's voluntary winding up. At least 2 meetings must be held. The first must be called as soon as possible after the final winding up order has been made by the court or the special resolution for a creditor's voluntary winding up has been registered, as per section 346, subsection 1. The purpose of this meeting is to allow creditors to consider the company's statement of affairs, prove claims against the company, and nominate a liquidator. Both the first and second meetings must be convened and held as far as possible in the same manner as meetings of creditors under the Insolvency Act, as per section 412, subsection 1. Further meetings of creditors must be authorized by the court, as per section 413. In the case of a company unable to pay its debts, directors and officers are obliged to attend the first and second meetings of creditors, as per section 414, subsection 1. The master may subpoena other persons to appear at such meetings for the purpose of being interrogated, as per section 414, subsection 2. An interrogation may be held after the first and second meetings and after confirmation of a final account. Number 23.5.2. Members' meetings. In a winding up by the court and a creditor's voluntary winding up, a meeting of shareholders or members must be held. It must be called as soon as possible after the final winding up order has been made or the special resolution has been registered or filed, as per section 364, subsection 1. The purpose of this meeting is to allow members to consider the company's statement of affairs and nominate a liquidator. If the company has already disposed of these matters in general meeting when passing a resolution to wind itself up voluntarily, no meeting need take place. The court may direct that further meetings of members be held, as per section 413. Meetings of members are held in the manner prescribed by the regulations to the Companies Act, as per section 364, subsection 2, or section 412, subsection 1. Number 23.5.3. Proof of claims. In a winding up by the court or a creditor's voluntary winding up, creditors must prove their claims against the company at creditors' meetings mutatis mutandis, in accordance with the provisions relating to the proof of claims against an insolvent estate, as per section 366, subsection 1. The liquidator may apply to the master to fix a time by which the creditors have to prove their claims, as per section 366, subsection 2. A creditor who does not prove his claim in time will not be able to benefit under an account lodged with the master before the claim was proved. In a member's voluntary winding up, creditors do not have to prove their claims. The liquidator simply settles all outstanding debts, realizes the assets, and submits his liquidation and distribution account to the master. Number 23.6. The liquidator. Number 23.6.1. Appointment of provisional liquidator. As soon as a winding up order has been made in relation to a company or a special resolution for a voluntary winding up of a company has been registered, the master may appoint any suitable person as provisional liquidator of the company, as per section 368. The provisional liquidator must give security to the satisfaction of the master for the proper performance of his duties. He is required to hold office until the appointment of a liquidator. The master may restrict the powers of a provisional liquidator in terms of section 386, subsection 6. However, a provisional liquidator may approach the court for leave to do anything necessary for the winding up of the company. Number 23.6.2. Appointment of liquidator. The master must appoint a liquidator. Number 1. In the case of a member's voluntary winding up, the person or persons nominated in the resolution lodged with a special resolution for the winding up of the company, as per section 369, subsection 1. And number 2. In the case of a creditor's voluntary winding up and a winding up by the court, the person or persons nominated by the first meeting of creditors in the initial meeting of members, as per section 369, subsection 2a. If these meetings nominate different persons, the master must decide whether either or both are to be appointed, as per section 369, subsection 2b. The master may decline to appoint a nominee if he is not properly nominated, or is disqualified from being appointed, or fails to give security timeously for the proper performance of his duties, as per section 370, subsection 1. The master may at any time appoint a co-liquidator, as per section 373. In terms of section 371, subsection 1 to 3, any person aggrieved by the master's appointment or refusal to appoint a liquidator may call upon the master to submit his reasons to the minister, and the latter may, after considering the master's reasons, any reply by the aggrieved party, and all relevant documents and information, confirm or set aside the master's decision. According to Janse van Rensburg versus the Master and others 2004, a person aggrieved for the purposes of section 371 only if his nomination of a liquidator has not yet been given effect to by the Master. However, in Geduld versus the Master and others 2005, it was held that this interpretation is too narrow. What is required is a legal grievance, and if a member or creditor does not want a specific person to be appointed liquidator, that constitutes a legal grievance. The remedy provided by Section 371 does not apply to the appointment or non-appointment of a provisional liquidator. Number 23.6.3. Persons disqualified from being liquidator. The following persons are disqualified from being nominated or appointed as liquidator in terms of Section 372, subsection A to J. Number 1. An insolvent. Number 2. A minor or any other person under legal disability. Number 3. A person declared to be incapable of being appointed as a liquidator for dishonesty or abuse of his position. Number 4. A person who has been removed from an office of trust by the court or who has been disqualified from being a director. Number 5. A body corporate. Number 6. A person who has at any time been convicted of theft, fraud, forgery, uttering a forged instrument or perjury and has been sentenced to imprisonment without the option of a fine or to a fine exceeding 20 rand. Number 7. A person who has, by misrepresentation or reward, induced or attempted to induce any person to vote for or nominate him as liquidator, or have been appointed as liquidator. Number 8. A person who does not reside in the Republic. Number 9. A person who has acted as director, officer, or auditor of that company at any time within the 12 months before the winding up, but in the case of a member's voluntary winding up, the auditor may act as liquidator. And lastly, number 10. An agent authorized to vote for or on behalf of a creditor at a meeting of creditors who acts or purports to act under such authority. If business rescue proceedings of a company conclude in a winding up order, any person who has acted as practitioner during those proceedings may not be appointed as liquidator, in terms of Section 140, subsection 4 of the 2008 Act. Number 23.6.4. Removal of liquidator from office. The liquidator may, on certain grounds, be removed from his office before he has completed his duties as liquidator. The master may remove the liquidator if, number 1, the liquidator was not qualified for nomination or appointment or has become disqualified, or if his nomination or appointment was for any other reason illegal. Number 2, the liquidator has not performed his duties satisfactorily. Number 3, the liquidator's estate has become insolvent or he has become mentally or physically incapable of acting as liquidator. Number 4, the majority in number and value of the creditors, or in the case of a member's voluntary winding up, the majority of the members has requested the master in writing to remove the liquidator. And lastly, in the opinion of the master, the liquidator is no longer suitable to be the liquidator of that company, in terms of Section 379, subsection 1, A to E. If the master does not remove the liquidator, the court may, in any of the above circumstances or for any other good cause, remove the liquidator on application by the master or any other interested person, in terms of Section 379, subsection 2. The court will hold that good cause exists only if it is satisfied that the removal of the liquidator will be to the general advantage and benefit of all the persons interested in the winding up of the company. In this regard, the court will take into account, inter alia, the impact that the removal will have on the liquidator's professional standing and reputation, and the expense, disruption, and inconvenience of employing a new liquidator to complete the work. Number 23.7. Duties of liquidator. Number 23.7.1. General function. The liquidator's primary duty in any winding up is forthwith to take possession of all the movable and immovable property of the company, to realize this property in the prescribed manner, and to apply the proceeds towards the payment of the costs of the winding up and the claims of creditors, and to distribute any balance among the members, as per Section 391. Whatever mandate the liquidator may have received from a particular creditor and whatever agreement the liquidator may have concluded on the company's behalf has to yield to this statutory duty. In a winding up by the court and a creditor's voluntary winding up, the liquidator must, when administering the assets of the company, have regard to the directions given by the resolution of the creditors or members, as per section 387 subsection 1 or 351 subsection 2. If creditors and members give no directions or conflicting ones, the liquidator may seek directions from the master, and if he fails to give any, from the court, as per section 387 subsection 2 and 3. The liquidator of a company stands in a fiduciary relationship to the company, to the body of its members as a whole, and to the body of its creditors as a whole. He must not only be detached, independent, impartial, and even-handed in his dealings with the parties interested in the winding up, but he must also be seen to be so. It also follows that he may be removed from office in terms of section 379 subsection 2 if he loses his independence or sides with one party or faction in a dispute concerning the winding up, or manifests hostility to an interested party. And the same applies if, through some relationship, direct or indirect, with the company or its management or some other person concerned in its affairs, he is in a position of actual or apparent conflict of interest. In Standard Bank of South Africa versus the Master of the High Court and others 2010, one of the two joint liquidators of a company had also been appointed as a liquidator of that company's holding company and other companies in the same corporate group, a practice often resorted to in group insolvencies. The court found that the liquidators had lost the required objectivity and had improperly failed to dispute a large claim proven by the holding company. They were removed as liquidators for having breached their fiduciary duties. Joint liquidators must act jointly in carrying out the required tasks. So, for example, a search warrant obtained by only one of them is invalid. Number 23.7.2. Providing information. The liquidator must give the master such information and allow him such access to the books and documents of the company as enable him to perform his duties under the Act, as per section 392. Number 23.7.3. Keeping records. The liquidator must keep records of all money, goods, books, accounts, and other documents received by him on behalf of the company, as per section 393, subsection 1. The master and any creditor may inspect these records, as per section 393, subsection 2 to 3. Number 23.7.4. Bank account and investments. The liquidator must open a current account in the name of the company with a bank and must deposit in it all monies which he receives for the company, as per section 394, subsection 1. He may also open a savings account and deposit it in it monies not immediately required for paying the company's debts. Number 23.7.5. Exposure of offences. The liquidator must examine the affairs and transactions of the company before its winding up in order to ascertain whether any of the present or former directors and officers of the company have contravened or appear to have contravened any provision of the Act or have committed any other offence, in terms of section 400 subsection 1. At the same time, he must establish whether there are any grounds for an application to court under section 219 for the disqualification of any director from the office. He must submit a full report to the master before lodging his final account, in terms of section 400 subsection 2. This report is then forwarded to the Director of Public Prosecutions if necessary, in terms of section 400 subsection 3. If there are grounds for an order disqualifying a director from taking part in the management of any company, that application is brought by the Director of Public Prosecutions in terms of section 401. Number 23.7.6. Report to creditors. Except in the case of a member's voluntary winding up, a liquidator must, not later than 3 months after his appointment, submit a report to a general meeting of creditors, in terms of section 402. The master may grant an extension of time for submission of the report. The report must deal with the following, in terms of Section 402, subsection A to I. Number 1. The issued capital of the company and the estimated amount of its assets and liabilities. Number 2. The causes of the company's failure, if it has failed. Number 3. Whether the liquidator has submitted or intends to submit to the master a report about contraventions by any of the directors. Number 4. Whether any present or former director or officer appears to be personally liable for damages or compensation to the company or for any debts or liabilities of the company as provided in the Act. Number 5. Any legal proceedings by or against the company which may have been pending at the date of the commencement of winding up or which may have been or may be instituted. Number 6. Whether further inquiry is, in the liquidator's opinion, desirable in regard to any matter relating to the promotion, formation, or failure of the company or the conduct of its business. Number 7. Whether the company has kept the accounting records required by the Act, and if not, in what respects these requirements have not been met. Number 8. The progress and prospects of the winding up. And lastly, any other matter which the liquidator may think fit or in regard to which he may desire the directions of the creditors. Number 23.7.7. Liquidation and distribution account. Number 1. Preparing and lodging. Within 6 months of his appointment, a liquidator must prepare and lodge with the master a liquidation and distribution account, or, if necessary, a liquidation and contribution account, in terms of Section 403, subsection 1. The master may grant the liquidator an extension of time for lodging the account, in terms of Section 404. The account should follow the form adopted for an insolvent estate. The proceeds of the company's assets must be applied in payment of the costs, charges, and expenses incurred in the winding up and the claims of creditors as nearly as possible as they would be applied under the law of insolvency, in terms of Section 342. Inspection. The account must lie for inspection at number 1. The master's office. Number 2. The office of the magistrate of the district where the registered office of the company is located, if there is no master's office in this district. Or number 3. The office of the magistrate of any other district in which the company carried on business, in terms of Section 406, subsection 1. The account must be available for inspection for whatever period the master determines, but not less than 14 days, in terms of Section 406, subsection 1. Any person having an interest in the company may inspect the account and lodge a motivated objection to it, in terms of Section 407, subsection 1. The master may either reject the objection or sustain it and direct the liquidator to amend the account, in terms of Section 407, subsection 2. Any person aggrieved by the decision of the master may, within 14 days after the master's decision, apply to the High Court that ordered the winding up of the company to have the master's decision set aside, in terms of Section 407, subsection 4. In Fundsale N.O. versus the Master 2000, it was held that since the master is the official whom the legislature has entrusted with administration of all estates, includes companies in liquidation, his rulings ordinarily deserve some difference. Hence, in exercising its powers under Section 407, subsection 4, the court will be reluctant to interfere with the master's ruling and substitute its opinion for that of the master, and will do so only if new facts have been placed before it, or the ruling in question is clearly tainted by irregularity or error. And number 3. Confirmation of the account. After the account has lain open for inspection and any objections have been disposed of, the master must confirm the account. The confirmed account has the status of a final judgment, in terms of Section 408. Number 23.7.8. Distribution of the assets. Once the account has been confirmed, the liquidator must distribute the estate or collect contributions in accordance with the account, in terms of Section 409. Unless the memorandum or articles provide otherwise, any assets remaining after payment of costs and creditors must be distributed among the members according to their rights and interests in the company, in terms of Section 342. Number 23.8. Powers of Liquidator. To perform his duties, a liquidator is vested with various powers. Some of these he may exercise only if he has the consent of the master or the authority of creditors and members. The liquidator may also obtain leave from the court to raise money on the security of the company's assets or to do any other thing which the court may consider necessary for the winding up of the company and distributing its assets, in terms of Section 386, subsection 5. Where a provisional liquidator applies for leave, the court need not consider the probability of a final order being granted, but should determine whether the powers sought are necessary for the proper exercise of the liquidator's fiduciary mandate. Number 23.8.1. Powers for which no permission is required. A liquidator may, by virtue of his office, do any of the following, in terms of Section 386, subsection 1a to d. Number 1. Execute in the name of the company any deed, receipt, or other document using the company's seal. Number 2. Prove a claim in the estate of any debtor or the company and receive payment of any dividend. Number 3. Draw, accept, make, and endorse any bill of exchange or promissory note on behalf of the company. Number 4. Summon a general meeting of the company or of creditors in order to obtain authority in regard to any matter he considers necessary. The liquidator also has automatic authority, subject to certain limitations, to take such measures for the protection and better administration of the affairs and property of the company as the trustee of an insolvent estate may take in the ordinary course of his duties and without the authority of a resolution of creditors, in terms of Section 386, subsection 1e. Number 23.8.2. Powers requiring the master's consent. A liquidator may perform the following acts if he has the master's consent or authority. Number 1. He may at any time before convening the general meeting referred to above terminate any lease under which the company has hired movable or immovable property, in terms of Section 386, subsection 2. Number 2. He may at any time before contravening the general meeting referred to above sell any movable or immovable property of the company, in terms of Section 386, subsection 2a and 2b. He must make a prior written recommendation to the master stating reasons why an immediate sale is necessary. The master may not give authority unless any holder of any preferential right over the property consents to the sale. A court cannot usurp the power which this section affords the master by purporting to authorize in his provisional order a still to be appointed provisional liquidator to sell the property of the company. And number 3. He may take urgent legal proceedings for the recovery of outstanding accounts, in terms of Section 386, subsection 4a. Number 23.8.3. Powers requiring authority of members and creditors. Most of the powers of the liquidator may be exercised only with the authority of creditors or members, or both. In a winding up by the court, the authority must be granted by meetings of members and creditors, in terms of Section 386, subsection 3. In the case of a member's voluntary winding up, the authority must ordinarily emanate from a meeting of members, and in a creditor's voluntary winding up, from a meeting of creditors. However, it has been held that a liquidator in a voluntary winding up may, in terms of Section 386, subsection 5, read with 388, subsection 1, approach the court for leave to exercise a power without first having approached the members or creditors to obtain their authority. The powers which require authority are as follows, in terms of section 386, subsection 4a to I. Number 1. To institute or defend legal proceedings, generally, urgent legal proceedings for recovery of outstanding accounts may be authorized by the master. Number 2. To compromise debts due to the company, or to accept part payment by a debtor in settlement of his debt to the company. Number 3. To compromise or admit any claim or demand against the company, including an unliquidated claim. Number 4. To make an arrangement with creditors except if the company is unable to pay its debts. Number 5. To submit disputes to arbitration. Number 6. To carry on or discontinue any part of the business of the company insofar as may be necessary for its beneficial winding up. Number 7. To enforce or abandon uncompleted contracts for the acquisition of immovable property where the company is unable to pay its debts. Number 8. To terminate contracts of lease. Number 9. To sell any movable or immovable property of the company by public auction, public tender, or private contract, and to deliver the property. And lastly, to perform any act or exercise any power for which the act does not expressly require him to obtain the leave of the court. Number 23.9. Interrogation and Inquiry. Number 23.9.1. Interrogation. At any meeting of creditors of a company that is being wound up and is unable to pay its debts, the master, presiding officer, liquidator, and any creditor who has proved a claim may interrogate any director or subpoenaed person about the company, its business or affairs, and its property, in terms of section 415, subsection 1. In principle, an examinee is not entitled to refuse to answer a question on the ground that the answer would tend to incriminate him, in terms of section 415, subsection 3. However, if an examinee does refuse to answer on this ground, the master or presiding officer may compel him to answer only if the former has consulted with the director of public prosecutions having jurisdiction. Incriminating evidence obtained at or derived directly from an interrogation is not admissible in criminal proceedings against the examinee or the company of which he was an officer, other than proceedings for perjury and related offences, in terms of section 415, subsection 5. Number 23.9.2. Inquiry by master or court. In the winding up of a company unable to pay its debts, the master or the court may, at any time after the winding up order has been made, hold an inquiry or appoint a commissioner to hold an inquiry into the trade, dealings, affairs, or property of the company, in terms of sections 417 and 418. The master's decision to hold an inquiry is reviewable under Section 151 of the Insolvency Act, but is not an administrative action and hence not subject to review under the Promotion of Administrative Justice Act No. 3 of 2000. The parties who may be summoned to appear are any director or officer of the company or any person known or suspected to have in his possession any property of the company or believed to be indebted to the company, or any person deemed capable of giving information concerning the trade, dealings, affairs, or property of the company, in terms of section 417, subsection 1. The presiding officer at the inquiry is bound to act in accordance with the precepts of natural justice, which enjoins him to apply procedural fairness and even-handed impartiality to all persons who might be adversely affected by his actions. In particular, the presiding officer must see to it that the inquiry is not conducted in an oppressive, vexatious, or unfair manner. The inquiry is essentially an interrogation in which information is sought to be pieced together so that the affairs of the company may be properly wound up. Although the master or commissioner appointed to conduct the inquiry is in overall control of it, the liquidator and any creditor, member, or contributory to the company has the right to interrogate witnesses in terms of section 418, subsection 1c. The presiding officer is under no legal obligation to provide examinees with a list of the topics on which they are to be interrogated or respond to questions regarding the subject matter of the inquiry. An examinee, for his part, has no right to disclosure of information or access to documents in the possession of the questioner, and is not entitled to refuse to answer questions concerning his dealings with the company until such disclosure or access has been provided. An examinee is also not entitled to rely on the right to a fair trial or potential loss of tactical advantage to escape examination on issues that are the subject of pending criminal charges. An examinee may be required to answer a question despite the fact that the answer may incriminate him. If the examinee refuses to answer on that ground, the master or the court may, after consulting with the Director of Public Prosecutions having jurisdiction, compel the examinee to answer in terms of Section 417, subsection 2b. As in the case of an interrogation in terms of Section 415, incriminating evidence obtained at or derived directly from the inquiry is inadmissible in criminal proceedings against the witness or the company of which he was an officer, with the exception of criminal proceedings for perjury and related offences in terms of Section 417, subsection 2c. Since Section 417 refers to the making of a winding up order, an inquiry in terms of Section 417 cannot be held in a voluntary winding up, unless it has been converted into a winding up by the court in terms of Section 346, subsection 1e. The reference in Section 417 to a company unable to pay its debts means that a Section 417 inquiry cannot be held if the company was placed in liquidation on the just and equitable basis, unless it is proved that when the inquiry was called for, the company was unable to pay its debts. Number 23.10. Impeachable transactions. In terms of Section 340, subsection 1, if a company is wound up and unable to pay its debts, every disposition of its property may be set aside. If the disposition had it been made by an individual, could be set aside if he became insolvent. The provisions of the law of insolvency will apply, mutatis mutandis, to the disposition. The company must be unable to pay its debts at the time the section is invoked by the liquidator or creditor. Number 23.11. Release of liquidator. When a liquidator has performed all his prescribed duties and met all the requirements of the master, he is entitled to a certificate to that effect. At the same time, the master must state that he consents to the reduction of the security given by the liquidator to a stated amount or to its cancellation, in terms of Section 385. Number 23.12. Personal liability and offences. The court may, in the course of the winding up of a company, inquire into the conduct of any promoter, director, or officer of the company, in terms of Section 423, subsection 1. If the court finds that there has been any breach of faith or trust in relation to the company, or that any property of the company has been misapplied or retained, it may order repayment or restoration of money or property to the company. Similarly, if it appears that any business of the company has been carried on recklessly or with the intent to defraud creditors, the court may declare that any person who was knowingly a party to the carrying on of the business in this manner will personally and without limitation of liability be responsible for all or any of the debts or other liabilities of the company as the court may direct, in terms of Section 424. The following should be noted in regard to this latter section. Number 1. Despite the fact that Section 424 still refers to winding up, judicial management or otherwise, its field of application is now restricted to companies being wound up, in terms of Schedule 5, Item 9, subsection 1 of the 2008 Act. Number 2. In considering whether a company's business has been carried on recklessly, the court has regard to the scope of operations of the company, the role, functions, and powers of the directors, the amount of the debts, the extent of the company's financial difficulties, and the prospects, if any, of recovery. The mere fact that the company trades while insolvent does not imply that its business is being carried on fraudulently or recklessly. The inquiry is essentially whether, at the time a debt was incurred, there was a genuine belief that the company would be able to pay it. Number 3. A person is regarded as having acted knowingly for purposes of the section if he knew of facts from which the conclusion might properly be drawn that the business of the company was carried on recklessly or with intent to defraud creditors, even though he may not have had actual knowledge of the legal consequences of those facts. Number 4. A director may be a party to the reckless or fraudulent conduct of the company's business even though he has not taken any positive steps in carrying on of the company's business. However, a person who, while carrying out his own independent business and without joining the company in a common pursuit, incidentally enables the company to carry on its business fraudulently or recklessly, cannot be regarded as a party to the carrying on of the company's business. Number 5. Although there need not be a causal link between the reckless conduct of the debts and liabilities in respect of which liability is to be imposed, the absence of a causal link is relevant to determining whether it is just and equitable to make an order. Number 6. A creditor's rights under the section are not extinguished by the sanctioning and implementation of a compromise. However, if the compromise results in the termination of the company's winding up, Section 424 can no longer be invoked. And lastly, number 7. Proceedings to obtain a declaration of personal liability in terms of the section may be brought in the name of the liquidator, acting nomina officio, or in the name of the company in liquidation. Number 23.13. Staying or setting aside of winding up proceedings. The court may, at any time after the commencement of a winding up, on the application of any liquidator, creditor, or member, stay or set aside the proceedings for winding up, in terms of Section 354, subsection 1. Such an order may be made either on the basis that the winding up order ought not to be have granted at all, or because supervening events render a stay or setting aside necessary or desirable. An applicant who seeks to stay or set aside winding up proceedings bears the ordinarily civil onus, regardless of whether the winding up is a voluntary winding up or winding up by the court. In reaching a decision, the court may have regard to the wishes of the creditors or members if proved to it by sufficient evidence, in terms of Section 354, subsection 2. For evidence to be sufficient for these purposes, it should indicate that the creditors have applied their minds to the matter, and it should provide the factual basis on which they have formed their view. More is required, for example, than a set of vaguely couched letters which fail to indicate any knowledge of the company's financial woes or shows why a postponement would be advantageous for creditors. The court may also intervene in a voluntary winding up and give directions on how that winding up must be continued, in terms of Section 354, subsection 1. Number 23.14. Dissolution and deregistration. The dissolution and deregistration of companies is regulated by Sections 82 and 83 of the 2008 Act. Deregistration entails removing the name of a company from the company's register, in terms of Section 83, subsection 1. The effect is generally that the company is dissolved, the only exception being where the reason for the removal is that the company is transferring its registration to a foreign jurisdiction, in terms of Section 83, subsection 1 of the 2008 Act. Although the terms dissolution and deregistration are used, these concepts cannot be separated. In a winding up, when the affairs of a company have been completely wound up, the master must send a certificate to that effect to the Commission, in terms of Section 82, subsection 1 of the 2008 Act, who has to record the dissolution of the company and remove its name from the company's register, in terms of Section 82, subsection 2 of the 2008 Act. In addition to this provision, Section 419 of the 1973 Act also continues to apply to this situation as it forms part of Chapter 14 of that Act. See Schedule 5, Item 9 of the 2008 Act. In relation to solvent companies, the provision of the 2008 Act prevail in the event of a conflict between it and Chapter 14 of the 1973 Act. Schedule 5, Item 9, Subsection 3 of the 2008 Act. However, the transitional arrangements are silent on the solution of a conflict in relation to an insolvent company. Section 419 of the 1973 Act is more onerous than Section 82 of the 2008 Act in that the Commission is required to publish a notice of dissolution in the Gazette in terms of Section 419, subsection 2. When a company is dissolved, its legal life comes to an end and nothing remains of it. If assets of the company were not transferred before dissolution, they accrue to the state as bona vacantia. The Commission is obliged to keep a register containing particulars of directors of dissolved companies which were unable to pay their debts, in terms of Section 421. A company that has ceased carrying on business can be deregistered on request to the Commission if it has been determined that the company has no assets or because of the inadequacy of its assets, there is no reasonable probability of the company being wound up, in terms of Section 82, subsection 3b2 of the 2008 Act.